A driver carelessly knocks a cyclist off her bike. She is rushed to hospital with a broken leg. At the hospital, a doctor makes a careless mistake during treatment, and the injury gets significantly worse. The driver's lawyer stands up and says one sentence: "My client did not cause that." Is he right? To answer that, you need to understand causation. Welcome to Storm Notes. Today's video is all about causation. This is the link the law requires between what the defendant did and the result that happened. This only matters for result crimes. This include offences like murder, manslaughter, and grievous bodily harm, or GBH in short, where the prosecution must prove the defendant's act actually caused the outcome. And causation has two separate stages: factual and legal causation. You need to satisfy both. Factual causation is tested using the but-for test. But for the defendant's act, would the result have occurred when it did? This comes from R versus White, 1910, where a son poisoned his mother's drink intending to kill her, but she actually died of an unrelated heart attack before the poison took effect. He was not factually liable for her death, because she would have died at that exact moment regardless of what he did. The poisoning failed the but-for test entirely. A simple test. But it is only step one. Passing the but-for test is not enough on its own. The defendant's act must also be an operating and substantial cause of the result. This is legal causation. It does not need to be the only cause. There can be more than one operating cause at the same time, but it has to still be playing a real part when the result occurs. In R versus Smith, a soldier was stabbed and received poor medical treatment afterwards. He died. The court held the stab wound was still an operating and substantial cause of death, even though the treatment was negligent. The original injury had not stopped mattering. This is the principle that decides whether the chain of causation has been broken. This is called novus actus interveniens, a new intervening act. Something happens after the defendant's act that is so significant, it breaks the chain of causation entirely, and the defendant is no longer legally responsible for the final result. There are three main categories where this comes up. First, medical treatment. This is the one that catches people out, so listen carefully. Medical negligence almost never breaks the chain. The bar is extremely high. In R versus Cheshire, the courts confirmed that even negligent treatment will not break the chain unless it is so independent of the defendant's act, and so potent in causing the result, that the original injury becomes merely the background to the story. Ordinary medical mistakes, even careless ones, generally are not enough. Second, an act by a third party. If a free, deliberate, and informed act by someone else intervenes, that can break the chain. Third, an act by the victim themselves. In R versus Roberts, a passenger jumped from a moving car to escape an assault. The court asked whether her reaction was within the range of responses a reasonable person might make in that situation. If yes, the chain is not broken. If her reaction was so unexpected or disproportionate that no reasonable person would have responded that way, it might break the chain. And finally, the thin skull rule. This is not an intervening act, but it matters here. You take your victim as you find them. If the victim has a pre-existing condition that makes the injury worse than expected, that is never a defense. In R versus Blaue, a victim refused a blood transfusion for religious reasons and died. The defendant was still fully liable. Their unusual vulnerability does not let the defendant off the hook. So, back to our cyclist. The driver's lawyer says, "My client did not cause that." But based on what we now know, careless or even negligent medical treatment almost never breaks the chain. The original injury is still very likely an operating and substantial cause of the final outcome. So, in a problem question, always work through it in order. But for test, operating and substantial cause, then check for any novus actus interveniens. If you want causation broken down on one revision-ready page, factual and legal causation, all three types of novus actus, the thin skull rule, and the key cases with exam application, the Storm Notes Lightning page covers it. Link is in the description. To summarize causation: factual cause, legal cause, and the three ways the chain can break, or more often, the reasons it does not. If this helped, hit like and subscribe. And don't forget the free resources available in the description below. We do have a question for you. Could you have argued the cyclist case before watching this? Drop it in the comments down below. Thanks for watching. Storm Notes. Zero fluff. pure knowledge.